This is Dimitri Lascaris for The Real News. Energy Transfer Partners, the company behind the Dakota Access Pipeline, has accused Greenpeace and other environmental groups of, quote, eco-terrorism. Energy Transfer Partners has sued the environmental groups for $300 million, claiming the group's resistance to certain projects broke federal racketeering laws. It alleges in particular that Greenpeace is part of a, quote, network of putative not-for-profits and rogue eco-terrorist groups, close quote, and that they use, quote, criminal activity and campaigns of misinformation, close quote, during the No to Dakota Access Pipeline protest last winter. In alternate, Jenny Neufeld describes Energy Transfer Partners' allegations against Greenpeace as jaw-dropping. The Racketeer Influence and Corrupt Organizations Act, or RICO, was enacted in the 1970s to combat the mafia. But this is not the first time that RICO accusations have been leveled against environmental groups. So are RICO charges part of a new playbook for fossil fuel interests to use in order to suppress opposition from environmentalists? Now here to discuss this with us is Thomas Wetterer, who is the General Counsel of Greenpeace USA. He joins us today from Washington, D.C. Thanks for joining us, Tom.
Sure. Thank you, Dimitri.
Tom, could you tell us in broad strokes, what are the ways in which Energy Transfer Partners, through its attorneys, alleges that Greenpeace and other environmental organizations have violated RICO?
Well, that's interesting you say in broad strokes, because that's exactly what this lawsuit is. And if you would believe what Energy Transfer is saying and what their attorneys are saying, any type of advocacy work, in this particular case with regard to the Dakota Access Pipeline, but in general saying that constitutionally protected advocacy work and free speech is should be criminalized. That's really what it comes down to.
And Tom, one of the more eye-catching allegations that I saw in the complaint relates to drug trafficking. Can you tell us what that allegation is all about?
I have absolutely no idea what that's about, except for a lot of the other things that are in the complaint. They're just ridiculous assertions that are just thrown on paper to try to make one reading it think there's some legitimate criminal behavior that went on here, which is just, not the case, and there's no basis for the racketeering claims, or really, quite frankly, any of the other claims that are filed here.
And part of the RICO claim, as I understand it, is that the statements being made by Greenpeace and other environmental organizations were false in material ways. What are some of the allegations in that regard, in terms of false statements, and how does Greenpeace respond to those allegations?
Well, first, we would respond to say they're without merit. There were no false allegations at all. Secondly, this kind of fits the pattern of another RICO lawsuit that was filed against us by the same law firm. And in essence, the allegation is that we made false statements, which we didn't, and that we knowingly made the false statements, and the allegation is by doing that we committed fraud. We know of no case that's out there that's ever found that a defamation claim could, even if there was, and there wasn't any here or in the other case, but we found no case where that could even be used as a predicate act to file a RICO case, as they're trying to do here and in the other lawsuit.
That other case I take it you're referring to is the case filed by Canadian company Resolute Forest Products against Greenpeace and other environmental organizations. Is that correct?
That's correct.
And what is the status of that, procedurally, what is the status of that RICO claim currently?
Well, procedurally, so it was filed in May of 2016, and now we're at the point and that was filed in Georgia. We got the case moved because it was improperly filed there in Georgia. Now it's in San Francisco, and there's a hearing scheduled for October the 10th at 2 p.m. in the Federal District Court in San Francisco to hear our motions to dismiss the lawsuit.
And the motion to dismiss is predicated purely for purposes of the motion on the allegations being factually correct. And I take it the position of Greenpeace is going to be that even if the factual assertions are correct, as a matter of law, the claim fails. Is that essentially what that motion is going to be about?
Essentially what it is, it's not on the facts, it's as a matter of law that in that case, Resolute and the Kasowitz firm did not even properly plead any plausible facts that could be the basis for any legal claims. We also have filed an anti-SLAPP motion under the California anti-SLAPP statute.
And could you explain to us what exactly is that statute all about?
Well, that statute is designed to protect advocates, like Greenpeace and others, from being sued for exercising constitutional rights like free speech and doing their public interest advocacy work. And it's designed to protect them from corporations, as in this case, from really using the law as a weapon that it should not be to silence free speech. And so since this really is about that other case, in this case is about free speech, then that puts an additional burden on the plaintiff that files that type of lawsuit to show the likelihood of winning at early stages, so that they're not allowed to drag the defendant through long and costly litigation, which is really what these cases are designed to do.
And if the court determines that either the Energy Transfer Partners case or the Resolute Forest Products case is a SLAPP suit, what, if any, are the cost consequences to the plaintiff in that case?
Well, if one were to win on a SLAPP statute, anti-SLAPP statute, then normally, and I know this is the case in California, it does allow for the defendant in that case to seek and collect attorney's fees.
Right, and the general rule in the U.S. litigation is that the parties bear their own costs. So this is part of the general rule.
That's correct.
Right, and let's talk about the costs for a moment. Can you give us a sense of the cost, both financial and otherwise, of an organization like Greenpeace having to defend a lawsuit that brings such inflammatory allegations against the organization and potentially would cost it hundreds of millions of dollars in damages?
Right. Well, it definitely is not cheap when you're talking about long, drawn-out litigation. I'd rather not get into dollar figures, and that will probably come out later. It certainly is also a time drain, and that's another reason for these cases. I mean, it does take a lot of time to defend these cases, a lot of staff time. It's not just attorneys, but others on staff, and it's really time that we'd rather be spending defending the environment, and that's really what these corporations want. They want to go after critics, and they want to tie them up in court and try to distract them from doing our public interest work, and they also want to chill others from doing the same. They want to send a message to others that, hey, don't mess with us, don't speak out, don't exercise your First Amendment rights, or we're going to come after you too, and also tie you up in expensive and time-consuming litigation.
Now, you mentioned briefly a few moments ago the law firm that brought forward this case on behalf of Energy Transfer Partners, and also the Resolute Forest Products case, Kasowitz, Benson,
right.
Torres. What can you tell us about this law firm?
Well, maybe I can just briefly start by saying there's an interesting article that just came out today, I believe, in Bloomberg Business Week, and the title of it is "How a Corporate Assault on Greenpeace is Spreading." And actually, I mean, I think the title may also be better said if it was worded "How a Corporate Assault on Advocacy or Democracy is Spreading." But within this, I encourage people to read it, but it does quote Michael Bowe, who's one of the lead partners in both cases, the Resolute case and the Energy Transfer Partners lawsuit. And he's come out and very, very clearly said that he's been in touch with other companies thinking of filing their own racketeering suits. And he knows others are considering doing this. So This is very clearly a ploy on behalf of corporate interests and led by Kasowitz. And I don't think it's a coincidence that Kasowitz is the go-to law firm of Donald Trump. I'm actually kind of surprised that they did not try to name the Obama administration as part of this criminal enterprise in this lawsuit, and because they were within that administration, they clearly saw the issues that we were speaking out on with regard to this pipeline. And then with this administration, Trump didn't waste any time in basically telling the Army Corps of Engineers to stand down so this project could proceed, just like all the other corporate interests that are being pursued by this administration. And it really is an attack on democracy and advocacy work. It's corporations through this government, through Kasowitz, possibly other firms and corporations that will come forward, but basically saying, stay out of our way. We're going to continue our environmental destruction, and don't even speak out against us.
You know, and something that's often lost in the discussion about these types of lawsuits is, you know, there's an unspoken assumption that organizations, I find often talking to people about this, that organizations like Greenpeace and these large corporate plaintiffs are more or less on a level playing field. But isn't it fair to say, and I know you don't want to get into the particulars, and understandably so, of Greenpeace's financial capacity, but isn't it fair to say that that assumption is sorely mistaken, and that, in fact, even if a corporation like Resolute Forest Products or Energy Transfer Partners loses this litigation and expends, you know, potentially millions of dollars in prosecuting it, that is not going to constitute a substantial part of its financial capacity. It might not even be material to the organization. But an organization like Greenpeace, if it has to litigate this case for years and it is ultimately successful, it could still be made to incur costs, both financial and otherwise, that have a devastating impact on the organization. Do you think that's a fair characterization of the balance of power in this type of litigation?
Absolutely, it is. There's just no comparison in terms of the amount of resources, and we operate in the public interest. And we really want to use the limited funds in the scheme of things to really put that towards our environmental work. And these corporations have something else in mind to divert us from that. And we're not going to be diverted. You know, this attempt to try to silence us is not going to work. It's really only going to make us more determined, quite frankly. And they really, I think they've picked the wrong fight, and you'll see in this lawsuit. I think we've seen it in Resolute, and we're going to see it more here too, where other groups are viewing this as a real attack on advocacy work. Who is next? If corporations like this are allowed to get away with these types of lawsuits, there's just no end in sight for what this means for, you know, basically exercising your constitutional rights to speak out when you see wrongs that need to be identified.